So the first topic is forms of protection. Are the current forms of IP rights suitable for AI companies? And the other people on the panel have had a presentation previously, but Mr. Risto Bruun hasn't had one. So Mr. Risto Bruun is from the Curious AI company, and he has agreed to give us an introduction to this topic. Curious AI is an AI startup founded by experienced AI people that has raised around $6 million of funding, or so I read. As Risto is their head of IPR, this topic should be close to his own experiences. Go ahead.
Indeed. Thank you for the introduction. I promise to keep this 2 minutes or less, so I'm going to be very efficient. I've been very happy to see that when we have been hearing about AI today here, we have been hearing about hardcore machine learning and not this wishy-washy AI stuff that is often talked about as AI. And I'm personally especially concerned with the IPR questions of machine learning because it's a tricky situation. The question here is, our first question is that are the current forms of protection good for AI companies, such as ourselves, AI startup? And in short, I think they are. I think that what AI startups and companies developing AI methods, especially in the general sense, machine learning algorithms and techniques, what they require is very much patent-like protection, because we are talking about methods in a general sense, so copyright doesn't cut it. Copyright has its role, of course, in software implementations, but usually we are not talking about a fixed body of work, we are talking about a method or methodology, and we go often very close to mathematical methods, which is a challenge for patenting, of course, but what AI business needs as an incentive to put the money and effort into the R&D is definitely patent-like protection. So what we use, what we rely on is patents and trade secrets, more or less. And then, well, trade secrets work. It's easy to keep stuff secret, but then those, of course, don't have the effect of getting the work published, and we don't have the society benefiting effect that we would maybe want to give with these kind of protections from the society's side. So patents is pretty much where it's at. The challenge with patents in AI business for me, when I go to a patent office and I want to protect the fruits of our labor, the challenges are pretty mundane as they are in other areas of business. So if I got to choose, I wouldn't require an AI-specific new form of protection, but the usual stuff, like more predictability for whether we will get a patent for something we have developed or not, transparency into that process, shorter times to grant, stuff like that. But my answer to this question would be that the current protections are pretty much what we need in the business.
All right. Thank you. Maybe Teemu can answer next, and we've agreed that we can use first names on the panel.
Yeah, thank you. I will be the first to admit that I'm really a complete dummy as it comes to IP protection laws and regulations, so I'll have to say that I don't know, but I will just say that from my point of view, I really agree with Risto that machine learning, AI and machine learning are pretty much business as usual as it comes to software and software-generated content. I don't really believe that it is fruitful, at least currently, to discuss AI as a creator. So AI is a tool, from my point of view, that's period. No qualifications, no sort of need to say that in most cases or in the near future, AI is a tool. And that means that we can use it for many purposes, and then and it's sort of it's software, and that it's simple as that from my point of view.
Thank you. And maybe Marco, if you want to answer next.
Thank you. I would like you to in fact, express that I coincide totally with the affirmation made by Risto before when he mentioned that patents play a very important role in the promotion of innovation in the area of artificial intelligence. And in that sense, I think the main challenge is to keep open the gate of patents in areas that are in the borderline of patentability, like mathematical methods, algorithms, and software implemented invention. The more clarity about patentability in that area, the more patents play an important role in the promotion of innovation in that area. Now, we need to keep in mind that there are certain developments that are either not patentable or are probably because of a strategic decision of the company decided to be protected through other means, and then trade secret, in fact, deserve a very special consideration. It may be that certain developments are clearly excluded from patent protection, and then trade secret is the option. But it even could be that the so-called negative know-how could be a good mechanism for disclosing certain knowledge that the innovator company would like to be available, but not available for protection through or by a third company. And in that sense, probably disclosing the information would be a mechanism to avoid protection by somebody else, and then being that company in a position of not being able to continue development. And finally, we should also consider in the area of industrial property, industrial designs. Particularly in the area of robotics, industrial designs plays a very important role. But in other areas, like in many of developments that for the consumer, the end product design plays a very important role in the consumer decision in choosing one option or another one. So industrial design is also, from the industrial property point of view, a category of IP that has, in my view, deserve also consideration. So as a conclusion to your question, in my view, what we have today in the industrial property area and the different categories available, in my view, are adequate options for the protection and adequate mechanism for the promotion of innovation in that side. Now, probably certain considerations needs to be made in areas like the traditional disclosure requirement in the area of patents, and how we will, and particularly patent office, will enforce the disclosure requirement in order to be sure that this equilibrium in between what the inventor discloses and what the inventor gets through the claim keep the balance that inspire the patent system. Just to mention one of those challenges. There may be others that needs to be think twice, needs to be think again in order to find out the adequate fine-tune needed, but without any doubt the system that we have today plays a very important role, and there is no need of dramatic or revolutionary changes to the system in order to accommodate the needs of artificial intelligence.
All right, thank you. And Jari, you can answer especially from the viewpoint of whether current copyright protection is suitable for AI creations or copyright companies with AI.
Yeah, I think if you look at the situation where you have the AI companies who are developing new kind of solutions or services, and on the other hand, you have the right owners, whatever the content might be, or any IPR-related material. So I think the key issue is the right balance of interests, so that if the protection is too hard, it might be difficult for our AI companies really to get the material and develop the solutions and the services, which is of course detrimental to all parties. But on the other hand, I can understand that the right holders have a kind of justified need to be sure that when you use your rights, that they are remunerated in a sufficient way. So, but I think that quite often you go in the wrong path thinking that this is primarily a legal matter, because I think it's, especially when you have a new technology, a new market situation, it's a contractual matter. So I think that instead of kind of trying to set a law in place when the market is just beginning and nobody has really a clue where it's going to go, it's better to kind of have this. But of course you need some kind of this fashionable term backstop so that for both parties, that making sure that you can experiment and have this different kind of pilot services, and the companies can pivot without having a too hard contractual constructions really to kind of deal with.
All right, thank you. Does anybody on the panel want to comment to the other comments, earlier comments?
Well, just quickly, I totally agree that we should be able to, or we should talk about contract solutions as well, especially when it comes to products or work that is generated with systems that include several data providers, designers of the systems, and the systems are becoming very, very complex, so they are composed of multiple components, and then the users. So these parties all are going to be eligible for some protection concerning the work, and there needs to be a contract. It would be kind of unrealistic that we could somehow write a law that says, you know, if you produce a photograph and then another user produces, you know, some style, how much of the protection or the royalties or whatever are going to each party there. This really needs to be decided case by case, and that's best done by contracts.
All right, thank you. So maybe we'll go ahead. So does the development of AI need the incentive of patent protection? So even going beyond AI companies, AI has survived until this point mostly without startups or applying for IP rights or so forth. Is it essential to the development of AI that you have, say, patent protection? Would AI be developed in the same manner, or would it slow down if we wouldn't have patent protection?
If we now stopped all protection for AI-related stuff, it would still get developed, because as you said, it has been developed to date. And that has been mostly in academia. And now we have this AI boom like never before, and it's also being developed by large companies who can afford the basic research R&D department, which doesn't need to give returns. So whether we had any protections or not, it would be developed. It would be developed in academia and by large corporations and entities who can afford it. But what it would do, it would rule out startups doing basic research or anything close to basic research, or getting funding for a far-out idea. Yes. For a startup or even an SME, in my experience, patents for anything, they are a strategic thing. So even grants are like 5 years away. They are beyond the immediate horizon of a small company. So the reason you hoard your IPR and you apply for patents is to give some strategic value proposition in the future to your investors right now. And I think that would be ruled out if small entities, SMEs and such, wouldn't have anything to protect their R&D with. So it would get developed. It would get developed by different people who currently do it.
Yeah, thank you. Does anyone else want to discuss this topic?
Well, I can.
Okay.
I would argue that the answer is yes. They play a very important role because of the following. If you see what happened in other sectors of technology with very intensive innovation, like in the bioscience, for example, what happened is when there is a massive interest for innovation, normally the boundaries of patentability are pushed in order to be able to give innovators a reward for the contribution. And in my view, the winter of artificial technology is associated with a period where not in all jurisdictions patents were available in that specific area. And probably, I have no conclusive evidence, and I don't have evidence in that sense, but in my view, the recent boom is linked to a period where patentability has been opened up in areas that are the key areas of artificial intelligence.
Thank you. Does anybody else on the panel want to still comment? Or is there any questions or comments from the audience at this point? Well, we can move to the next topic. So, big data and open data versus copyright and privacy. So, AI methods often require large amounts of training data, but are the required quantities of user data only available to certain large IT companies? Their existing customers are often willing to agree to end-user license agreements that are convenient for the companies. And this user data can include users' personal data that is private and creations by the users covered by copyright. Oftentimes the platform, the big IT company that provides the platform gets certain rights from the users due to these end-user license agreements to use the data in their own development and so forth. So who wants to go first? Teemu, do you want to say something first?
No, I'll be happy to. So one of the actual sore points of data protection that machine learning has sort of put a lot of light upon, or sort of put in the center, is exactly this kind of data sort of privacy in the context of user data being handled and processed by companies mostly. And I think I think GDPR is underappreciated. I think it's a wonderful thing. It, of course, it requires that there's a lot of work done, and we need to we need to sort of push a lot of these consent buttons, which might be very annoying. But actually what it says about the right of the user to know what data is collected of them, how this data is being processed, and even the right to be forgotten when requested, I think these are really, I would sort of think that if GDPR didn't exist, we'd really very soon need to create something similar. And I think that's a good starting point for thinking about the kind of data. So I think data ownership is not the right thing. Because data can't be owned. It's not something that I have and I could then sell to you, and I wouldn't have that anymore. What we need to talk about is the right to access and use the data in certain ways. And that's what the My Data movement, for instance, emphasizes. I'm not sure why they kind of call it My Data, because that refers to ownership, really. But it's really what the whole movement is about, is on the controlling the access to the data, to private data, of course, in this context. And I think that's what we certainly need to talk about. And like anonymity and the threshold where something is private data and where it is anonymous data, that has been confused a lot with machine learning technology, that you can kind of identify users even though they are in principle anonymous. You can identify the users if it's anywhere, sort of if it's high resolution data, it can be identified. The user can be identified. And that's a huge challenge because the demand is that if you use some data, it is private data if the user can be identified even later, even in the future. And now we're supposed to sort of be able to tell what is going to be possible in the future in terms of that. And that's a very tricky question. That's sort of one of the kind of new questions, this identification of the user from anonymous data or pseudonymous data. That's a kind of a new question that we're dealing with.
All right, thank you. So,
I'm not sure if everybody else loves the GDPR as much as I do. Maybe not.
First time I hear about that.
So, Jari, do you want
Yeah,
to comment?
coming back to my point about the contractual relations, I think when it comes to copyright protected work, so I think it's very crucial whether you're talking about commercial usage or non-commercial usage. Of course, you can say that, well, if I, as a right holder, give a permission to use something for a non-commercial, let's say, research development work, so and this is aiming this AI company to create a commercial product, what I'm getting out of that. Of course, there can be kind of non-direct benefits also for the right holders, getting information and getting experience, how it works. So it's, once again, it's not either or situation, but you can kind of divide it into smaller areas or have these walled garden areas where you can experiment and learn so that both parties can benefit, which is not directly commercially beneficial to either, but really kind of work together and trying to find solution also for the future usages.
Yes, thank you. So, Marco or Risto, do you want to comment? Maybe Risto first.
While I do agree with, like, it's good to have data protection and whatnot, maybe I don't feel so strongly about GDPR as you do, but still, I think it's important to keep in mind that although this question isn't, this isn't the first time I hear this question that does Google or whoever have a huge upper hand in AI because they have the user data, but all data is not user data. And GDPR and everything, it only applies to this personal user data and AI applications specifically handling those things. But there are infinite amount of other AI use cases and applications and business areas, so it's not that bad. And the other thing that I think is weird about the whole personal data discussion is that the data somehow has value, and it has gotten to the point where it's imagined to have some like intrinsic value, that Google owes me something like $1 because they know my data. But nobody would buy my data alone for $1. The reason a big data set has value is that the holder of the data set also has an application for that data set. So even if I personally got hold of all of Google's data right now, it wouldn't be as valuable to me as it is for Google because they also have something to do with it. So somehow this personal data discussion has gotten a bit off the rails already, in that we are talking about people's right to the value of their own data in that collection, when that value, I think, was created by the party who collected the data in the first place and got the idea to do something useful with it.
Yeah. Thank you. And Marco?
Yeah. Something that is very evident, but sometimes is good to mention again, is what makes artificial intelligence so relevant today is not only the technology, but the fact that this technology is able to analyze and use a huge amount of data that exists. So it's not one or the other, it's both together what make the distinction. So defining who can use that data, which condition you can use the data, is key for the development of artificial intelligence. And you have, I would say, two main models. The US model, where there is a kind of, I would say, is accepted that companies deal with the data generated by users in a way in which the company owns the data. And the European approach where it is considered that the user owns the data on the existing regulations that have been put in place. So this two approach, probably time will tell us which is the right one and which will promote faster development in the area of artificial intelligence. But what, in my view, is making a huge difference today is that in certain jurisdictions, particularly US and China, with a huge amount of data and technology available, is moving faster than regions like Europe, where you have the technology, but probably the data is, I would say, more fragmented through different elements like legislation, but other elements like language, for example, that in principle is a huge advantage and have a great richness and value for many purposes, including cultural purpose, but may be something that in terms of the data development and management may have an impact that is not necessarily in the right direction.
All right, thank you. Does anybody want to comment on the other comments? Yeah, so how could you level the playing field, or do you need to level the playing field? Do you need the society to somehow provide a data set for everyone to use, for instance? Or do you, how could you compete then with, you took the example of Google. Google has all kinds of data. How can a startup then compete against Google if Google has all that data available to it? Or is this just an irrelevant question? There will be new companies that get their own data and there will be competition and so forth. So who wants to answer or comment?
No, I mentioned Google, but it's often said that they had such a huge head start that nobody just can compete, and that's it. And maybe they do. Yeah, I mean, in that area of business, in mining huge amounts of web search data from individual users and providing them ads or something. I mean, there are business areas where they have gotten a huge head start, and that's why they generate more data from there, because they provide a service to those people who provide the data and so forth. And it might be uncompetitive. It could be. But it's not only a matter of my not being able to found a new startup who does these things, but I would also need to provide the service. It's not just about the data. Not everybody who gets the same data can still do the same service.
Yeah.
So it might be that we can't level that playing field, but I don't see a huge immediate reason for the need either, frankly. I mean, good for them.
Yeah. Does anybody else want to comment?
Yeah, it's a very good question. It's an interesting question. Like Google in particular and their dominance of the advertisement market. I mean, that's what they dominate in terms of their business. It's of course what we use is their services and the search engine, but that's a small part of course. That's how they kind of collect the data, but then selling the ads is how they make money. One thing that I think sometimes is forgotten when we discuss this, like playing fields and different countries versus other countries, or one company versus the others, or on the third hand, I guess, the industry versus academia, is that still Google can't do pretty much anything alone. They need to collaborate with the huge ecosystem of collaborators, both industrial and academic. Any research that they do, they have to work with the top researchers in academic institutions. So they have very wide and deep collaboration networks and collaborations with several universities all around the world. And it's not like they would be, if it's like a sort of huge building or huge facility somewhere where the researchers go and they do their work and nobody hears or learns about what they're doing. That's not how it works. Science has always been sort of working with a huge team from sort of multidisciplinary teams from all over the world. And you can't just sort of, you can't, there is still a tiny part of the research community. And if they would isolate themselves from the rest of the research community, they wouldn't get anywhere. They would just immediately stop compared to the progress of the global scientific community. So it's not like they are actually doing anything alone. They have to collaborate. And that's sort of why it also might not be such a big problem that they are maybe in this one market sector so much ahead. They're not sort of dominating the science in any ways, which is still what they rely on when they try and compete with who predicts the customer preferences better. And I think that's kind of alleviating the problem. They can't sort of isolate themselves. They're still not an island, and they're dependent on the support of the rest of the world.
All right, thank you. Marko or Jari, do you want to comment?
I think about this competition situation, a playing field. So I think in internet economy in general, it's the winner takes it all situation in many ways, like what Facebook has, status has, Google has, and so forth. So I think if you really want to compete on serious level, you really have to, the only way is to break the rules and to be able to create something totally new. And of course, the other possibility is to build on the existing systems and companies something which explodes in a way. But of course, it's not really competition. It's more like a benefiting out of the existing structure and system. So it's very intriguing and very complex and fascinating subject.
Okay, thank you. Okay.
If I may ask, sort of add once again, sort of as you noticed, I'm a big fan of GDPR. So I sort of more generally, I would like to say that if we have these dominant players in the market, then they won't be forced to operate in certain ways or constrain whatever applications they have for the private data by the competitors, but then the society or the legislation has to do that. And that's why I think it's so important that Europe has taken a strong position in enforcing regulation on global companies. So any company, including Google, Facebook, whatever, that have customers in Europe, they have to follow the legislation or regulation in Europe in order to be able to operate here, and they can't miss that opportunity. So I think we should really see the benefit of that, and of course not only see that as constraining innovation, but also enabling innovation through like patenting and sharing of knowledge, which can sort of, the regulation can have that sort of it can enable innovation and sharing, and not only kind of that sort of slow us down, which many people seem to think that Europe is lacking behind because we're slowing down innovation by regulation. We can sort of do the opposite, and that's what we should be thinking about.
Yeah, okay. Thank you. So, are there any comments from the audience on this topic? All right, we can move to the next topic, to shifting and developing AI. So there have been many AI booms and also subsequent winters. And during each boom, you have often had exciting new examples what AI could do, but it wasn't obvious what AI at each time wasn't suitable for. Is the current boom fundamentally different from the previous booms? Again, the limits of AI are not clear at the moment, or the current version of AI. So who wants to go first? Teemu?
If I may continue, so I just shut up, but if you are willing to listen a few more words, it is different. Yes, my answer is that it is very different from before. The previous booms, if we refer to the 60s or the 80s boom, they were mostly promising that we'll solve AI. And they were saying that now we have identified how AI works. In the 60s, it was basically neural networks. In the 80s, it was logic-based or reasoning systems, expert systems, they call them. And the idea was that we'd figure out what is intelligence. We'd figure out how AI works. And then once we do that, then we get all these applications, whatever applications we like. Now we're doing it the other way around, and we're doing these applications one after the other without bothering to think about what is intelligence, is awareness related to that, is there something different from non-aware things to to the ones that are self-aware. So we've kind of skipped the bit that seemed impossible and still seems impossible to me to understand consciousness and awareness. And we're kind of bypassing that, and we're going straight to the goodies, the applications that we have. And since we already have those, there's no, I mean, how could that sort of somehow disappear? Imagine that. I can't see all AI applications suddenly going away, right? And we wouldn't have Google, we wouldn't have any recommendation systems, anything at all. How could that suddenly disappear? I don't see that possibility.
So would they just not be called AI anymore? So you mentioned
the terms can change, of course, and then I wouldn't sort of want to say that it's all sort of true, and it is like a miracle thing. And I'm not like a snake oil guy, but there is a lot of hype. But still, there is we use these technologies all the time. So, and that's the difference. Before we couldn't have any of the applications. We all only had promises, but now we have the applications, and that they were not going to go away suddenly like that.
Okay, thank you. Anyone else on the panel? Yes, Risto.
I wholeheartedly agree, and there's certainly going to be an AI winter because there's somebody out there who wants there to be something called AI winter. And the past winters you mentioned, I think they happened mostly in the academia. So there was this great hope and funding was given, and then they didn't deliver, and then everybody got super depressed, and then there was a couple of years before anybody could get more funding for AI again. But like you said, now we are going applications first, and those are not going anywhere. There's not going to be a Google Maps winter, where everybody just abandons that. The applications will work and get better, and we get the AI piece by piece. And also, we now have more AI stuff going on. We have it outside academia as well. We have big corporations and national efforts and everything going as well. And that's going to even it out very nicely. So it's not about a very well-written funding proposal anymore. There's actual, well, call it momentum, maybe, this time.
Yeah. Thank you. And Marko or Jari, do you want to?
Well, I probably would sound repetitive because I do agree with what had been said, and maybe it's different, and it's different because there are elements now that were not at the time. Big data, the capacity of processing information were not at that point. But there is also something different is developments in the understanding of the human being, and these developments in the knowledge we have about how the human brains work and how to interpret human behavior is something that was not at that level of maturity in previous artificial intelligence booms. So in my view, is different what is happening today compared to what happened before because of those reasons. And secondly, because the statistics shows that those leading innovation in that area are mainly private sector now. As we identify in the statistics, in the case of Europe, US, and Japan, it's mainly corporations and private sector leading the research, and it's only in China with mainly leading entities are public research institutions and university, but in the rest of the world, it's mainly private sector leading. So I'm sure those innovations and patents for the protection of the innovations are going to be there for quite a while.
Okay, thank you. Jari.
Well, one thing which I've been pondering is that when you have a look at the history of technology and inventions, you have a lot of stories where the actual invention has been, the final usage of that invention has been totally different than it was supposed, where it should be used or aimed to use. So the classic example, for example, is when Edison developed phonogram. It has a long list of potential usages, and music was not one of them, even though it was kind of predominant form of recording music for a long time. So one issue which I have been pondering is now with the AI, is it going to be used in a totally different way that we figure out right now? Is history going to repeat itself, or is it impossible in this case because it's just a flexible and convenient tool for doing many things? So, but it's more like an open question to my esteemed colleagues here. That do you foresee that there will be these kind of surprise is coming that the AI is used in ways and for purposes that we simply don't figure out right now.
Does anybody want to comment?
I would say that absolutely, that's what's going to happen. And the AI methods, even if they are developed for one thing, they end up using for something completely different already today. And that's actually one of the things that kind of bugs me about like patenting guidelines nowadays, is that you want this technical character by tying the, say, a neural network method to something physical or something concrete. So you kind of need to fix that I have this phonograph and I will use it for bird sounds. And that's the protection you get, and that needs to be your business case so that patenting this gets you the investor funding.
Yeah.
When actually you develop the phonograph, that's a rather generic thing, and the end killer app is completely different then.
Yeah, at least in the patent application, you need to have those specific examples of the technical application areas, and then you can sometimes get a broader scope of protection in the granted patent, but nowadays, at least in Europe, you have to be fixed to a certain technical problem, technical data.
Yeah, exactly. Or then it's a silly game of just listing all kinds of different things and hoping that you guess which one is your killer app a couple of years down the road.
But at the current point, using AI for a different set of data is quite obvious in a sense. You know, I think most AI practitioners would say that, yeah, why not use AI on it? You have a new data set, why not use AI on it? So it's difficult to get a patent in that way, that if only the application area is somehow generic, and then you just mention a new one. Okay. I think we had a question in the audience. Anna, right in the front. Or comment.
Yeah, thank you very much, and thank you for the speakers so far. With regard to the question whether this boom will be the final boom or whether there will be other booms, probably yes, there will be other booms, but this boom is it's really significant in the way that the technologies that are coming out of these AI. Different sorts of AI techniques will probably not be shut down in the same way that previous ones have been kind of shut down, in the sense that, well, even if it's a good idea, we don't have the processing power, or even if it's a good idea, we don't have the content, or something is missing. So I think here we have kind of the the perfect situation, basically, to use the technology, the knowledge that we have already, and knowing also what could happen if we don't. So I mean, there is a significant impact, I say, for the copyright and the creative market and the creative people, because if we don't make the management of copyright easier through the improved metadata, through improved use of data on works and authors, the users of creative content will turn to AI-created content. Because, I mean, it's natural. Of course, if you don't get licenses to something you want, you take the next best thing. And if it's a really good one, somebody might even not hesitate, to ask the human beings who have been creating. So I think here it's really like something that all right holders should look at, and also the technology people to look at together, how to improve the metadata in order for us to really take this opportunity to develop something of a better infrastructure for copyright management in the future. We don't need new laws, we need just the better infrastructure on this, I think.
Thank you. Yeah, and in previous booms, you often used AI methods on new kinds of data when you didn't know the proper way of doing the thing you wanted to do. You tried AI first, and then afterwards, at some point, you understood the data, and you had an engineered solution, hard-coded rules, and that was usually better than the AI solution or machine learning solution. But now, during this recent boom, the machine learning solutions are actually better than the hard-coded rules, or even better than a human in certain visual tasks. So, all right. Any comments?
Can I comment?
Yeah.
So I really like the point that we need to be able to, you used the word metadata, so that's kind of identifying who contributed, in what ways, where the data comes from, sort of this accountability, transparency into the systems. And that's of course a big question, even if we're not talking about copyright, if we're talking about liability, if we're talking about let's say there's a problem that a system malfunctions and then there's some damages, who is liable for those damages? And if the system is very complicated and we don't know exactly which part of the system caused the malfunction, or if it was some data that was used by the system, we can't sort of trace back what were the kind of, how did we come about in making that decision which was harmful. And the same goes for the copyright. So if we don't know how this work was created, who and which parties provided the data, where the data came from, how it was processed, how it was used, say which part of the data was used, which part wasn't, then we can't decide these questions, the hard questions about copyright either. So I think that is it's a big challenge. So I think sort of there are two kind of new kinds of questions, almost new kinds of questions that machine learning and AI sort of force us to think about. And these are, as I already mentioned, the kind of issue of de-anonymization, that we can sort of identify individuals from data that we couldn't identify them from before, and then this accountability or transparency when the systems get complicated and there's different data providers and all that. So these are and these are kind of technical questions. We don't, as you say, we don't really need the new law, but we need to be able to understand the systems, their behaviors. We need to make them transparent enough so that we can identify who is accountable, who is liable, and who gets the credit.
All right, thank you. Any other comments? Oh, there in the audience.
Yes, thank you for a great afternoon. I have a question about standardization. My name is Jarkko Vesa. I'm the chairperson of the Finnish Standardization Committee at FSS, which is the Bureau Committee of ISO. And as you may know, ISO started last year the standardization work for AI, and also big data was merged into this new committee. So I'm just curious, how do you see the relationship between the IPR and the patenting world and the standardization world? What we are seeing is that mainly it's the academia and the large corporations that are participating actively in the standardization work. The startups are too busy developing the applications, and the standardization, the clock speed of standardization work seems to be a bit too slow for these very energetic young companies. So how do you see, do these complement each other or compete with each other? I mean, patenting, IPR versus the standardization world.
Yeah, you can say. Talk about it.
Excellent question. And I would say this particular area of technology is not different to what is happening already in other areas of technology, where standard essentials patents plays a very important role. Let me start with your last comment. I cannot see any competing factor here. I only see complements in between the different policy instruments, because they are looking for different goals. In the case of patent, we want to promote innovation through giving these exclusive rights. And in the case of standards, we want use that actors in a given sector, technology fields agree on what is the standard to be adopted for everybody to be able to produce on that standard. And in the different areas where standards have been implemented, they contribute in a very important manner in the development of the technology in that area. There is a reduction of cost, there is an amplification of user, there are a number of very positive outcomes coming from that standardization. When tension exists is when the standard that have been adopted coincide with a patent that is in the hand of one single actor. And in that case, as you know, they have been different developments worldwide and how to handle with that situation. One option is within the standard setting organizations rules and how you need to disclose that a given technology that is part of that is analyzed as an element of a standard, as soon as is disclosed, it get into given rules and agreements and how others can use that technology on the certain condition, particularly the so-called FRAND license agreements. And in case of infringement, whether the possibility of injunctions are or not available. So that tension exists. But the way so far a standard setting organization have been dealing with that, in my view, have made able that technological development continue in parallel with those standards being put in place. I guess the progress of the discussion in the artificial intelligence field will learn from what happened in other fields and most probably will be able to put in place solutions at those that have been put in place in other technological areas.
Yeah, thank you. And I guess there are already existing standards that you can have AI developments in, video coding, for instance, and so forth. But for instance, in self-driving cars, you probably want some similar to medical standards. Somehow you need to be able to prove that they are safe and reliable. So that's one thing. Does anybody else want to comment on this? All right, thank you. I think we have about used our time, so we won't go to the fourth topic. But I want to thank all the panelists. It was an interesting discussion. This was my first panel that I've led, and it wasn't awful. Thank you.
It's about time to thank everybody. I want to first of all thank our speakers and the panelists. I think that this has been a wonderful seminar. And secondly, I would like to thank everybody in our office and everywhere else who have in one way or another contributed to the success of this seminar. I'm very pleased with the outcome. But most of all, I would like to thank you, my dear audience, to come over and participate in this event and being active. Now I would like you to give a big applause to each and every one of us. And now there is a cocktail event and a networking in the Winter Garden. Please join us there. Thank you.